Oh, I see you found your way to Steno 24/7. And just because you're here, I'll be dictating selection number 34. 791 words on the subject of furnishing necessaries to wife. This will be at 120 words per minute. Jury charge. Ready? Let's write. Ladies and gentlemen of the jury, it is the law of this state that a man, when he enters into the marriage relation, takes upon himself the duty of supplying his wife with necessaries. And if through his own fault he does not, the wife, by reason of the marriage relation, has the implied authority as his agent to procure such necessaries, and the husband is responsible for what is so supplied. If the husband refuses to furnish necessaries to his wife, she may secure them elsewhere, and he is liable under the law therefore. However, one who sells goods to a wife can recover from the husband only upon proof that the husband authorized the purchase, or that he refused or neglected to provide a suitable support for his wife, and that the goods sold were, in fact, necessaries. The term necessaries in this regard is not limited to articles of food and clothing required to preserve life or personal decency, but includes such articles of utility or ornament as are suitable to maintain to the wife according to her husband's station in life. Now, the plaintiff claims that the goods furnished were necessaries, and that same have not been paid for. When a person renders services or furnishes money or goods to another with the latter's knowledge and consent, the law presumes that the person for whom which services were performed or goods and money furnished intends to pay for the same. When a person claims that such goods and money were furnished voluntarily, the burden of proof rests upon such person to prove by a preponderance of the evidence that such goods and money were furnished without expectation of compensation, or that the same were not to be paid for. And even though there was no contract of sale, for the presumption is that payment was intended.